Good afternoon, everyone. This is Akshay from 𝗧𝗿𝗀𝗀𝗃. I'm very glad to bring back to you this webinar on intellectual property rights. Today, we have with us Mr. Saransh Chaturvedi, who is an advocate practicing in Allahabad High Court. He has a long-standing experience of working in intellectual property rights. Today, we'll be discussing a lot of issues regarding infringement, etc. I won't take much of your time, and I would, pass on the baton to Mr. Saransh Chaturvedi. He can take the session ahead. Thank you so much, everyone, for joining in.
Thank you, Akshay. Thank you, 𝗧𝗿𝗀𝗀𝗃 team, for having me here once again. So when just I will share my screen. Is it visible?
It is coming. Yes, we can see it now.
Perfect, right? Is it all right?
Yes, it's working fine.
Yeah. So thank you so much for having me here. The topic of trademark opposition, classification, and infringement is a very important topic for all those who wants to start in trademark litigation. In the previous webinar, we have discussed about trademark selection and prosecution. I don't know how many students were there in the previous webinar, but yeah, I will try to put up in a way that if those people who have not attended the previous webinar, they could also get the glimpse of what we have discussed in the previous one. So the previous webinar was primarily based upon trademark selection and trademark prosecution. Now, when we talk about trademark selection, we discussed regarding how we are going to select the trademark. When we are trying to deal with this selection of trademark, we have to keep ourselves very much caution about how we are selecting the mark, whether it is a fanciful mark, whether it's an arbitrary mark, whether it's a collective certification mark. So primarily, we have four types of trademark. When we are into the selection of trademark, we have four types of it. It is about fanciful, it is about arbitrary, it is about descriptive, it is about generic. So when we are going into choosing the mark, it's very important to choose the mark within these parameters. Well, as an advocate and as a practitioner and as an advisor to my various clients, I would just rather suggest all the people to have a trademark selection in terms of having a generic or an arbitrary mark. That's very important when we try to talk about having a trademark in this, having a trademark of a very strong protection. Now, when we are dealing with this selection of trademark, then what becomes very important is the classification of trademark. Well, the topic of this webinar is trademark opposition, classification, and infringement. But I will try to put first of all the trademark classification. What are the classification and where we can get this classification into a overall purpose of having a good and a strong trademark protection. Now, trademark classification, right? So before getting into the classification, it's very important to understand why and how it is classified and why it is necessary to have a classification of trademark. Now, classes of trademark is generally used for the registration of trademark. What happens is that it helps to recognize and differentiate among thousands of trademarks that are applied, right? So in schools we have classes, we have sections. So why we have all those sorts of sections is because we understand that, okay, fine, this student belongs to this class, this student belongs to that section. So in that ultimately that level of philosophical approach is being applied in trademark when we try to classify these all trademarks into some of the other domains, right? So there are lots and lots of goods and services. So the international classification, perhaps when all the WIPO and all the people member states meet, there was a need to have a classification of trademarks so that those people who are either registering or rather who are the registration, who are doing the trademark office, is able to substantiate and is able to derive as to which trademark is in which class. This will help in keeping a substantiate data of all the trademark with respect to the goods and services that particular product is being developed upon, right? So when we try to talk about these classifications, we have to recognize and differentiate among thousands of trademarks that are applied, right? So as I told you, it becomes easy for the trademark office to identify the similar goods and services that are registered under the same class, right? So if I am making a, let's say an oil or rather an automobile, So when I will registering my trademark, I will be putting my class in the automobile section, which will easily define my mark as a mark which is my goods and services, which is an automobile. So this will be having a good data perception, and that will also prove very good for the all the data analysis, and the trademark office also will able to recognize as to which mark is there. So this is the whole basic concept of why we need a trademark. A trademark classification for the business to search in their own class monitor. This helps to recognize goods and services using similar trademark. Now, one thing is very important. Like we know Lux soaps, right? So when Lux will go for a trademark registration, it will use the classification under the class of which the class that defines the goods as a soap, right? But if tomorrow I start a business known as Lux chocolates, right? So I will be going for a trademark classification that will be under the trademark which is known as, let's say it will be chocolates or eateries or food and beverages. So we both have the same trademark, but we both have a same different classes, right? One is having a soap, another is having a food and eatery. That is also possible in the in the present trademark classification and in the present trademark regime, because ultimately the present trademark regime talks about not having a trademark of similar goods and services. So tomorrow, if I am using that the use of Lux in terms of chocolates, that is perceptibly available in the trademark classification because we are using a different class. I will come to this after a while when we were discussing the case laws, right? So we have basically in the international classification, we have two types of classification, that is known as NICE classification and Vienna classification. Now, NICE classification was established under the NICE agreement in 1957, which classifies the goods and services for registering the trademark. This NICE classification is generally being administered by the WIPO, that is World Intellectual Property Office, right? And it gets updated every 5 years. Right now, we have 45 classes of NICE classification, in which the class number 1 to class number 34 is goods, and class number 35 to 45 is services. By goods and services, I think all must be aware about. When we talk about goods, it's goods like a mobile phone or something like that, automobile, oils. These are the goods, example of goods. And when we talk about services, or telecommunication services, postal services, these are all the services. So these classification has been done in a very comprehensive manner in these classes of class number 1 to 34 and class number 35 to 45. This is the NICE classification. When we talk about Vienna classification is generally used for the figurative element of what you say mark, right? When you are having a logo or a figurative element, then Vienna classification and then Vienna codification comes into the existence, right? So when you are trying to have a mark which is considered as a figurative mark or a logo, when you are registering it, then it has to be go to the Vienna codification, whereby all the codification is being done through the code number. I have given you the example also. So Vienna classification is having 29 categories, 145 divisions, 816 sections, and 918 auxiliary sections. So let us assume one thing, that if suppose your figurative mark is having a children who is a girl child who is crying. So your Vienna codification will be as follows. Category 2 will be human being, category division 5 will be children, section 3 will be girl, and auxiliary section 19 will be children crying. So ultimately your codification of your figurative element will be 2.5.3.19. So this is well, it is very confusing when you try to deal with these Vienna codifications. That's why this Vienna codification is generally done by the registry. So these are the codification of the figurative element, right? Understand, when you are trying to deal with the goods and services, NICE classification will be used because to substantiate whether your product is a goods or services. And when you are having a figurative element or figurative mark, having a logo type thing, having something which depicts some logo structure something, then it will be in a Vienna codification in different categories, division, sections, and auxiliary sections, right? So for NICE classification, I have given you example, like class 5 is a pharmaceutical. So when you are having a pharmaceutical drug, then you will be applying in the class 5 trademark classification as when you will be going to the IP India site, and when you are registering for the trademark, then there is an option of class, which class are you registering, and this will be class 5 pharmaceutical. When you are having a scientific or research navigations, you are having a compass, something like that, then you will go for class 9. Then if suppose you are having a gun AK-47, then you will be going for class 13, right? But suppose let's say you are having a telecommunication service tomorrow, if Geo wants to register its trademark, then they will be going for class 38, and class 39 will be transport packaging services like Blue Dart and FedEx and something like that. So these are the these are the comprehensive classifications which have been done by the NICE agreement, and which has been done by all the member countries in the world, so as to create a database, and so as to not create any confusion in the minds of other people, or in the minds of trademark office, or in as a business personality, right? So India is signatory of all NICE classification as well as Vienna agreement. For it, both follows. We follow both, right? And here the NICE classification has been mentioned under the fourth schedule of Trademark Rules 2002. So you have to understand these are the NICE classifications, and you have to differentiate between the two, because when you are trying to deal with goods and services only to depict what is, whether you are having a goods or a service, you have to go for a NICE classification. And when you have a figurative element, you have to go for a Vienna classification. One thing is very important also, that it is Madrid classification. Madrid classification is nothing but it is an international trademark system, whereby various member countries is there in the trademark classification of Madrid. What happens is that when you are having a registered trademark, then if you want to have a registration of that particular trademark in the whole world, or whether in the countries whereby all the countries are having if you want to have a registration you have a registration in India, but you want that your registration of trademark should also be there in various other countries. So we have a Madrid agreement, whereby around 123 countries are there. So when you are trying to when you have a registration in India, you can also go for a Madrid registration, trademark registration, which will enable your trademark protection in 123 countries, all the signatories of the Madrid agreements, whosoever countries are there in the Madrid agreement, all those countries, your trademark registered will be there in all those countries. So you cannot go as an individual. You have to go through a trademark office. First of all, you need your registration in India, and then further on, you have to go for the Madrid classification in the international arena. So these are the basic level of classification. You have to understand that when you are opening up a business, when you are opening up a, let's say, any firm business, first of all, you need to classify your product or your services, right? Which services you are trying to deal with, right? And then the next process is trademark selection. In this trademark selection, you will be going for the fanciful, arbitrary, that we discussed in the previous webinar, fanciful, arbitrary, descriptive, or generic marks. So first of all, you classify your goods and services, and then you come to the trademark types, whether your trademark is having a figurative, or sorry, a trademark, a generic, or something like that, and then you will be going for a registration. So these are the three processes which is very important when you try to deal with the registration as well as selection of trademark. Probably then I will be moving on to the trademark opposition. If anybody has any confusion of trademark classification, or if they want me to repeat something, please let me know.
Um, I have one question in the chat: how to deal if a good or a service falling with more than one classification, if you have not taken it?
So the thing is that when you are having a different class in India, we are allowing a multi-class option available. So there is an option where you can just register your trademark in various classes, class number 6, class number 7, class number 8. Even multi-class options are available. And only thing is that when you are applying in multi-class option, your statutory filing fees will be increased. So multi-class options are available in India. Akshay.
Yes, yes. I think we have dealt with difference in NICE and Vienna classification, right?
Yeah.
So I think we can move ahead with it. Anyone who has missed it, you can check it later on. It would be available on YouTube, right? So those of you who are joined late and missed it, we cannot delay it for other students, right? So you can check it later. Thank you.
Okay, so and nobody has any confusion, right? So okay, fine. Before going on to the opposition, I will also deal with one more point. Is that it is about how to deal with if you are having a mark, and that mark is having, like, let's say, same category, same class, then how to deal with this? So there is one famous case, Nandini Deluxe versus Karnataka Cooperative Society. In this case, it is the latest case of out in 2018 or 2019. In this case, what happened is that Nandini Deluxe was a company which has a trademark registered as a Nandini Deluxe, and which used to sell, I think, eateries and food beverages. And there was a Karnataka Cooperative Society which also went for registering the word Nandini, and they sell cow milk and buffalo milk, right? So there was a dispute in both of those people regarding the using of Nandani Deluxe, the word Nandani as a trademark. So very important point comes, Supreme Court says, it said that whenever you are having a similar class, if you are having registration in a similar class, let's say class number 8, let's say class number 8, your class, you will, your registration of in class 8 will not debar others to register in the same class. Because, so let's say if you are having beverages and if you are giving, let's say, burger, that does not mean that if your name is being used by some other who are using that name for cow milk or buffalo milk, that will be debarred, right? So one has to understand that even if you are having a registration in one class, you don't get a monopoly of all the products and good in that domain. You have to make yourself very much clear. Food and beverages means you are having, if Nandani Deluxe was in the food and beverages industries, whereby it used to give all snacks and something like that, and this cooperative society was dealing with the cow milk and buffalo milk. So even if it is coming under the same class, you don't get a monopoly of all the things that can be considered under that same class. That has to be understood. And one more thing, that there is a very much important question that arises as to whether if you are having a trademark registration and that trademark registration does not fall in any class, right? So it is close to very impossible that you don't have any class and you're not able to you're not able to search which class is there. It is a confusing purpose, but in all the classes there are lots of subcategories and other things are given. So it is close to impossible if you are thinking that, okay, fine, if I have a product or goods or services which don't fall in any other classes of a nice classification, then how to deal with this, right? So it is close to impossible. We have this classification is so comprehensive that all the things are available in that classes, which we have to search, and it is something somewhat confusion, and that's why you can take help for all those trademark attorneys also. They help in dealing with which class you can come, right?
So there is one question. Does putting more than two classes, can it create confusion?
No, when you are dealing with the multi-class options available, then you have to prove and you have to put evidences that, okay, fine, your let's say, I don't know the example anymore, but okay, let's say if you are having a multi-class, let's say you are coming in class 6 and class 7, and you are having a mark, let's say any mark. So when I am having a same mark and I will search it in the trademark registry, in the trademark registry, it will come class 6 and class 7, right? So there cannot be any confusion because all the documentary evidences will be available on the trademark website as to how and why you are taking up these classes, right? So the confusion will not be there even if there is a multi-class applications also. It is all evidences and all documented will be available on the website whenever you will search it. So no dealing with confusions. Akshay.
Yes, sir. I think we can move ahead.
Okay. Okay. Thank you. So now we will be dealing with the opposition and this infringement, right? So opposition and infringement are primarily what the law says in India, in trademark law, whatever the things are there available in India. I have tried to make this opposition and infringement whole issues of both of the opposition and infringement in a very comprehensive manner and in a very easy manner, so that you will remember all every time. So when you are marking your taking up to the registration of your trademark, your mark, you will get two things. Two type of refusals are always there. One is objection and one is opposition, right? So there is a lot of confusion between these two of objection and opposition. So when you are trying to deal with the mark and when you have registered, you have filed, put the trademark form, you have filled the form and you have given it to the trademark office, the first thing that will come is that objection. Objection will always come from the trademark office, not from any individual, right? You have to make it very clear. Objection will always come under section 9 and section 11. Section 9 says absolute ground and section 11 says relative ground. Yes. So ultimately when you I think section 11 is I am confused about this. Section 11 is relative ground and section 9 is absolute ground. So when you are registering it, when you are trying to put your form, then if you are having if trademark office or the trademark registrar think that your mark is something deceptively similar, and in the first stage itself it is there is a confusion that your mark cannot be able to move further, then registrar will give you an objection under either section 9 absolute ground, section 11 relative ground, right? So objection will come from the trademark office. After the examiner qualifies it for registration, it publishes in the trademark journal. Trademark journal is always available on the trademark website, IP India website, in every time updated on Monday. So whenever your mark qualifies at the stage one means if you are having a mark that qualifies itself from the mark, let's say it qualifies, the trademark registry is absolutely clear and absolutely fine with your mark, then you enter the condition, and then you enter the whole issue of opposition, right? So you have to make yourself very clear that opposition is something which will come when you have cleared the stage one. It's not that you have it will come in the stage one. It will come whenever you have cleared the stage one. It means that you have satisfied the trademark office, and then only opposition will come. Make sure objection will come from the registry office and opposition will come from the third party, right? So it is after the publication of the journal, then opposition starts. And if you have qualified the stage one, then only you enter the opposition stage, right? So opposition, trademark opposition is being defined, it is being mentioned in section 21. Any person within 4 months from the date of advertisement or re-advertisement of any application gives notice in writing in a prescribed manner. So let's say today your publication is done. So 4 months, like March or April, it will be giving you a time of 4th month. In within the 4 month time, you have to make yourself very clear that you should not go beyond 4 months. 4 month is not extendable. So within 4 months, you have to put your notice to the registry office that, okay, fine, now I will now this registrar which is being now this mark which is being registered under the trademark journal is being is deceptively similar or is infringing my trademark, because it's not possible for a registrar to overall every mark in the country, right? So it gives you it gives an option to the third party anywhere, whosoever is available. It gives an option to the third party whatsoever, that if you are having any confusion, okay, it's fine, it has crossed stage one, but still to clear all the doubts, it gives you the option to the third party, to the world, whenever whosoever is sitting wherever, he can file a trademark opposition, right? Procedure of opposition is being specified under the trademark rules of 2017, right? So you have all the procedural things are being given as to how you have to proceed when you are thinking that, okay, fine, this mark is infringing my trademark, registered proprietor. Now, I have dealt with 5 stages. Basically, we have 5 stages of opposition. First of all, notice of opposition. As I told you, within 4 month time from the date of publication, a copy of opposition be served to the applicant by the registrar, right? So when it is available to the registrar, when you are giving it 4 months, within 4 month time, you are giving it to the registrar, okay, fine, this mark A is infringing. Then after within 3 months of the receiving of the opposition, then registrar will serve the notice to you who is registering it, that, okay, fine, we have received this opposition, you answer it, right? Now, rule number 44 will say counter statement, right? Within 2 month times, as soon as I will get the notice from the registrar, okay, these are the oppositions. Within 2 month time, I need to file a counter statement. Within 2 month time, you have to make yourself very clear. In section 21 clause 2, it is very strictly maintained that if you are not able to reply within 2 months, then your trademark will be abandoned. So you have to be very clear that, okay, fine, your trademark, your counter statement has to be there within 2 months, right? And then evidence in support of opposition. So when you have filed the opposition, when you have filed the counter statement, then the opposition, the party who came for opposition, gets 2 months time to put any evidences. If you have any evidences, if you have any documents, if you have any something which substantiate your case things, then you will be giving that particular evidence in support of your opposition within 2 month time, rule number 45. And rule number 46, the evidence in support of counter statement. Again, that party who is registering the mark also gets an opportunity within 2 months to give your evidence of opposition in to the opposition of counter statement, right? So when you are dealing with these things, when you have got the evidences, then again, one time more, the opponent will get the chance so as to prove that this chance is only being given so as to prove and so as to have no doubt that if opponent has any doubt or if an opponent has any further documents which can substantiate his case, rule number 47 gives one more chance to the opponent to also file any document in respect to the counter statement. And then rule number 50, that comes to hearing. At least 1 month after the date of first notice, hearing is appointed. The registrar can call both the parties and hearing can be done. If the registrar decides an aggrieved party is there which is not happy with the decision of the registrar, then you have the chance to go to the IPAB within 3 months time, Intellectual Property Appellate Board, specified under rule number 125 and also in the trademark side, right? So I will repeat it all the section and all the rules to make it very clear. Stage 1 is opposition notice. You have registered, you have crossed the stage 1, means you have general registration, you have published your mark in the trademark general. Notice of opposition is the first one. Within 4 months, I have to give notice to the trademark office that okay, fine, this mark is infringing. Now within 4 months after we have received the opposition, then we will be going, then the person who is registered will be going for a counter statement, and then within 2 months you have to give the counter statement. Then comes the evidence part. Evidence is in support of opposition, evidence in support of counter statement. These are the stage 2 and 3, rule number 45, rule number 46. And then rule number 47, remember, opponent will always get one more chance to give or to substantiate his hearing. And then rule number 47 will come, whereby all the document, if he wants again to submit, it's just because if there is some counter statement or the evidence is being given in the counter statement which the opponent doesn't know, that's why this rule number 47 gives one more chance to the opponent, and then hearing is being given, right? If you're not satisfied with the decision of the trademark office, you can go to IPAB, Intellectual Property Appellate Board. Rule number 125 says that within 3 months. Let's say if you are even not happy with the decision of IPAB, you can go to the writ petition in the High Court, as well as then it comes to the Supreme Court. So you can just go to the Supreme Court also, no issues within that parameter. So these are the opposition stage of, these are the opposition 5 stages in India, prevalent in the India, and also maintained in the trademark rules of 2017. Any confusion till this, if possible, I can repeat it. Akshay.
I haven't received any questions on the topic, but there is this one sort of practical question which may be a little off topic. Is it important to have enrolled in Bar Council of India for filing a trademark, or can anyone file?
No. Even if I am not even a third party, you don't need to register yourself as a Bar Council of an advocate. Even any business, if he knows these all things which I'm telling, if suppose if any businessman is seeing this webinar and if he's understanding all these things, there is no need for having any advocate, even if he has not done LLB, even if he doesn't know L of LLB, then also he can easily go to trademark office, trademark website, and can register himself. No need for having a Bar Council registration.
One question was, how does the objection against section 11 and 9 is answered? What is the main difference between these two?
Section 9 and section 11. Section 9 of the Trademark Act is absolute ground and section 11 is relative ground. We discussed very in depth in the previous webinar. So I will repeat it. See, when you are giving your mark to the trademark office and then trademark office is giving you an objection, there are 2 grounds of objection, either section 9 and either section 11. Section 9 says an absolute ground and section 11 says relative ground. These are all very big sections. Just a brief or what are these two. Absolute grounds means prima facie your trademark is infringed or your trademark cannot be registered. Absolute means, by the name said, absolute, there are some clauses in the section 9 which you can study, which means that you are absolutely infringing something. Like, if let's say if you are having a trademark which is let's say infringing the National Symbols Act, right? Or the symbols or the India flag or something like that, which is very much which is pertaining to something national security. Absolute infringement, absolute ground, where as soon as a trademark officer will see, it will be definitely rejected because absolutely it is not into the domain, right? Now section 11 is relative ground. Relative ground means that section 9 says absolute means prima facie your mark cannot be registered, but section 9 gives you some scope of registration. Section 9 are relative grounds, which means that they are not so absolute and they are not so strict grounds, but there are some grounds, there are some deceptive similarity which the trademark officer can see and can give you an objection under section 11. When you are getting an objection under section 9, primarily it becomes very difficult to give you the answer. to the trademark office. When you are getting an objection under section 11, there are varied scope, so that you can answer yourself, and so then you can prove that, okay, fine, even if it is relative ground, you can prove that it is not deceptively similar. You have to make yourself very much understand that these all opposition which I told you, almost similar process is also in objection. When you are getting an objection from the trademark, also within a time frame, you have to prove your, you have to reply to the trademark office. Again, the trademark office can give you some examination report. Your adverse examination report can, you can receive. Again, you have to fill the counter statement, even to the extent that you can also request the trademark registrar, so that you can have a physical hearing, right? So this is the objection which only concludes between you and trademark office, and these are the section 9 and 11. You can understand where it is very simple: absolute and relative ground. When it goes beyond trademark office, then it comes to opposition. I hope I'm clear.
Thank you so much, sir.
Should I is there any other question?
I don't see any questions as of now.
Okay, okay. So now comes infringement. It is also very important. Infringement of trademark. Section 29 gives you the infringement, the area of infringement of trademark. Now, in simple words, as the name suggests, if you are unauthorized use of any registered mark, or a use of mark that is deceptively similar or identical with. Now, what is more important in this infringement is section 29 says about registered trademark infringement. That's why I have put registered into a quote. I will be deliberating in this perspective in the next or in the couple of my slides. Now, trademark infringement is, section 29 deals with the direct infringement. You have to make yourself very much clear that we have two types of trademark infringement. One is the direct and other is the indirect. Direct infringement is which is something which is very available on the trademark site, and you can just clearly find it out. Indirect infringement does not see itself in the Trademarks Act, but it has a value in this. I will be dealing in a couple of in the upcoming slides, right? So what is the direct infringement? Right now, section 29 deals with this direct infringement, right? So why? One, use of an unauthorized person. Second, identical or deceptively similar goods. Registered trademarks, similar class of goods and services. So these are the direct. When your mark is, you are an unauthorized person and you are infringing some other's mark. You are having a mark which is identical or deceptively similar. You have a mark which is registered. You have a mark with similar goods or services. So you have to make yourself very clear that these are the direct, means you are directly infringing it. There is no indirect infringement of any trademark. Directly infringing, you are clearly possible and clearly prima facie you can see that it's a direct infringement, which is a registered trademark of a registered trademark, right? So there is also an indirect infringement, as I told you, not only direct infringer, but also those who induces in a direct infringement. Now, very important, you have to understand that these indirect infringement can be of two types: contributory and vicarious. First of all, as I told you, direct infringement means if you are directly infringing, prima facie, okay, you are having a mark which is deceptively similar to that, no issues, you are in under the purview of section 29, right? But when you are, if you are having indirect infringement, indirect infringement basically tries to say that, okay, fine, if you are having if your mark is there, and let's say if you are a company, or your company is infringing your mark, you are not a direct infringer, but you are inducing it. You know that it is infringing, but still you are maintaining false records. You know that your employee is infringing your another trademark. In all these cases, these are particularly the case which you have studied in law of torts, vicarious and contributory negligence. These all cases are applicable in this trademark registration. If your company is infringing, you and you know that your company is infringing, still you are keeping quiet and still you are infringing, you are continuously infringing, you are directly liable for the infringement. You know that infringement, but you are silent on this, all indirect infringement. These are all the contributory. The concept is similar to the law of torts, right? Only one section, I think section 1.14 is something which it can be said indirect inference can be given for this indirect infringement, where section 114 says that if a company commits infringement under the act, all those who will be responsible for the company will be liable, right? So very important. We used to study direct infringement. there is also indirect infringement. And indirect infringement means if you are not even directly infringing, still you can be liable if you know and if you have the knowledge of all the infringement. It's similar to the case of all these things which we have studied in the vicarious liability, an employer and employee relationship, or you are deriving some financial gain of that, and you know that okay fine, you are having an infringed trademark, and then you are gaining the all sort of financial growth also. All these will come under the indirect infringement also, right? So one thing that is very important in this is passing off, right? What is passing off? Now, in this previous slides, what I did is I put the code under the registered trademark, and I told you that I will be dealing with this. So section 29 deals with the trademark opposition when trademark infringement when we talk about a registered trademark. You have to make yourself very clear that in India we don't require a registration of a trademark. Meaning thereby, even if your trademark is not registered in India, still you will get ample of protection in India, even if your trademark is not registered, or even if you have not even thought of registering your trademark, right? So it's very confusing, and most of those people who knows about the passing off knows the extent and the extent of confusion it creates. Like even if you start a firm and if you don't have a trademark registration, even in the case of that also, if you find that any other person is infringing your trademark, you are having the whole right to give or to pull him in the court under the passing off. You have to make yourself understand. Passing off means the security that is being provided to you in the form when you are having an unregistered trademark. Registered trademark, if you are having an infringement, go to section 29, or if you are having an indirect infringement, go to 114. But if you don't have an unregistered trademark, trademark act provides you the relief in passing off also. No need to have a registered trademark if you don't have a registered trademark. Now, what very important is we have to prove these are four things, basically four things. These are the modern elements which was dealt in the case of Town End. You must have heard this famous case. You have to make the court understand that okay, there is a misrepresentation, and the person was in the course of trade. You have to make yourself very clear again that you have to prove okay, you are having a similar goods and services, right? So this misrepresentation and this course of trade has to be similar. If you are dealing with the let's say food industry, you have to make yourself very clear that other person who is infringing your trademark, even unregistered trademark, is also in the food industry, similar goods and services, right? So this is very important, right? So second is this becomes the point number 3, and point number 4 becomes very difficult to prove and very important in trade passing off. It is about calculating the injury of the goodwill, because when you are getting into the unregistered trademark, you are first of all not having any statutory remedy, no remedy under the law, right? But still you are providing this remedy as per the passing off. So when you are going to court, the court, like if you are having registered trademark, you don't need to provide anything regarding goodwill or injury. Your registered trademark is infringed, that's all. You are coming under 29, that's all, okay, fine. But when you are going under the passing off, you need to prove this goodwill situation. This goodwill situation is very important. You have to prove the court that okay, fine, this is something which is being unregistered trademark, but since it is unregistered trademark, my goodwill and my injury and my market is being hampered. It is very difficult to prove, but yeah, you have to prove it when you are going for the unregistered trademark. That's why we have all sort of thing that you please register a trademark, because it becomes very difficult when you are going into the passing off. And you have to also prove that you have this unregistered trademark is causing some actual damage to the business or goodwill of the trademark or by whom the action is brought. So these things has to be understood that okay, fine, goodwill is being injured and your there is some financial hampering of your business to for the unregistered trademark. So you have to make it very clear, right? Direct, indirect infringement 29, and then passing off. Okay, coming forward, section 134 says all suit of trademark infringement and passing off will be instituted in district court, right? So these are all things which is in the law, which we all know. Two types of remedies: civil remedies and criminal remedies. Civil remedies can be enforced. You can ask for civil remedies. All these things can be enforced, like injunction, permanent remedies, damages, John Oy order, Anton Pillar order. For those who don't know, Anton Pillar order means that you are getting into you are having the permission from the court to enter the premise of the defendant to search and seize the documents and these things, right? So if you are getting an enter and pillar order, it's also very difficult to get an enter and pillar order from the court. But if you're getting it, you are having whole right to enter into the the premise of the defendant, and to search, seize, and all to rectify and to see all the documents that is being there in the premise, and which you think that okay, fine, he is hiding some documents in this in his premise or in his house, right? So this enter and pillar order will be getting you the right to enter the premise of defendant. A John Doe order is means that it is an order by the court to again search and seize the premise, but in this case it is an unidentified defendant. So that is also very difficult for the court to understand who are the unidentified defendant, but this is also a remedy that is being provided. You can also ask for Anton Pillar and John Doe order in civil remedies. Now when we talk about criminal remedies, undoubtedly section 103, 104 of the act talks about seeking criminal remedies. Both seek criminal remedies, both have a maximum imprisonment of 3 years and having a maximum fine of 2 lakh rupees, right? Section 115 also gives the power to the police for search and seizure. Court not less than metropolitan magistrate or judicial magistrate of first class will try the offense. And in this case, 115 also says that section 103 and 104 shall be cognizable. So these are all the trademark registration process, and these are all what law is. The only thing that you have to make yourself very clear about the difference between what is passing off and what, if you are going into the passing off criteria, what all things you have to keep in mind, right? Passing off, and you have to keep in mind, if you are dealing with the indirect infringement, you have to deal with this contributory and vicarious, and you have to put your mind in the terms of law of torts as to why vicarious and contributory negligence can be put up, and direct infringement section 29 is clear, right? So this was the whole sole basis of how the trademark infringement used to get into the domain of in India, right? And if anybody has any confusion, okay, fine. We will take questions afterwards. I will be also dealing with the case laws, which is very important for our understanding for the case laws. So, sorry. So these are some of the case laws which I try to deal with, so as to make ourselves very much clear as to what are the infringement and how infringement is being primarily done, and how infringement can be done, right? I dealt you a case of Nandani. Now these are some of the case laws. Like first case is Facebook versus Teachbook. It is, I think, the case of California, whereby one other company started a social networking site of Teachbook by the name of Teachbook. What it did is, I think, they started a social networking site of teachers, and they named it as Teachbook. Facebook says that this Teachbook and is deceptively similar by the face on the terms of Facebook, right? So Teachbook says that Facebook cannot have any right over the generic word of book. The book are common, right? So it cannot have a generic word of book. So the court decided in favor of Facebook. Again, coming to the point of classification, you have to make yourself very much clear. I gave you an example of Lux soap and Lux chocolate. So the book can be generic, but Facebook is having is such a well-known trademark, and has such an important that even if you are having a teach book that is having a similar goods and services, means that you are dealing with similar goods and similar services, like that of Facebook, which is of telecommunication and then social media networking, then it definitely will cause confusion in the market, in the mind of people. So you have to make yourself very much clear. Tomorrow, if let's say Facebook is there, and you start a business called as Face Air of an airline business, Facebook will not be able to claim infringement on your mark, because you are using the word face for goods and services which is different from that of Facebook. You have to make yourself very clear. There is a lot of confusion. Even if you are having a goods and services which is similar, the name is similar to Facebook, but that is something which is different goods and services, like Facebook, or let's say Face Air, which is airline companies. You don't have any infringement of Facebook mark, right? But in this case, Teachbook and Facebook was almost similar. In this case, both of the both of the company was for the purpose of social media networking, right? Similar case, McDonald versus McCurry. So when we see Facebook and Teachbook, we see, okay, the importance of book, right? But in this McDonald and McCurry, it is, I think, the case of Malaysia, in which McDonald clarifies and McDonald says that the word Mac being used by McCurry is infringing their mark, right? But the decision was different from what we see in Facebook and Teachbook. The top court of Malaysia said that it is not an infringement, because Even if McDonald is there and Mac is associated with the McDonald's, the goods that is being dealt with the McDonald was burgers, and Mac curry was basically for the those vegetables and curry business, right? Both are having same eateries business, but the particular product of eateries was different. So this has to be made very clear. Again, I told you that if you are having a goods and services, if you are having a similar class, like the case of Nandani, even if you are having a similar class of registration, you don't get a monopoly on everything that is there available in that class, right? The perfect example is McDonald versus McCurry. McDonald was defeated and McCurry won because McCurry was only into the business of all these curry and fish curry businesses, right? And McDonald, even if both classes are same, they don't have a similar product. This is the both are the very famous case, and both cases teaches us how important these classes are there and how important it can be. Similarly, a case of Starbucks versus Sambuck. This is the similar case. Sambuck was being denied. I think it is a case of US only, whereby Sambuck was denied. It is deceptively similar, and Sambuck was denied the use of this mark because it is Starbuck and Sambuck is almost similar to that, right? Similar case, Starbuck versus Sardar Baksh. In below, I think you can see I have also put up the both the icons of Starbuck and Sardar Baksh, right? Both have started the business, I think, in Delhi. Sardar Baksh started a business of outlets of coffee outlets. Starbucks claimed that Sardar Baksh is infringing their mark. Again, Sardar Baksh was defeated. Delhi High Court says that this Sardar Baksh, even if it is somewhat Sardar is something else, Star is something else, but when you are pronouncing the name, they are coming almost phonetically similar, right? So this is very important because even if the name is different, phonetically similar is also the thing, right? Here, understand, Facebook and Teachbook book was exactly same, right? But Starbuck and Sardar Baksh was phonetically similar, but does not mean that they are all the spellings are all same, right? So Starbuck and Sardar Baksh are phonetically similar in this case of having a mark. So Sardar Baksh was the High Court said that Sardar Baksh is will create a confusion in the mind of the people, and that's why you should delete the name. So Sardar Baksh gave the name of Sardar Ji Baksh. I think it is available. You can see this icon, Sardar Ji Baksh. So this was a very famous case and very hilarious case also. So Starbuck and Sardar Baksh was there. Yahoo versus Akash Arora, very famous case. Almost you must have been knowing this case. This was the, I think, probably, I think it is the first case whereby the domain name of our website is also considered under the infringement of trademark. Yahoo is a well-known trademark, everybody knows it, and Akash Arora was the person who started Yahoo India. What he did is also, when you are going into the Yahoo India website, he also put a disclaimer whereby he said that, okay, fine, if it is it's not the Yahoo which you are thinking of, it's Yahoo India. Yahoo put up a case of infringement in Delhi High Court, and Akash Arora was told that even if you are putting up a disclaimer in in internet, these disclaimer won't work, and you have the same thing, and even if it is domain name, still domain name is eligible to get all the protection that is being given to the trademark. And this is the case. I don't know any previous case before this which protect the domain name. So Yahoo and Akash Arora was the first case which protected the domain name as a part of a trademark. Now we know that all this domain name also comes under the trademark protection. Coca-Cola versus Bisleri, very famous case again. It shows how your jurisdiction differs, and the difference in the jurisdiction may also affect your business, right? So what happened is that Bisleri gives the Bisleri product Maaza. The word Maaza was given to Coca-Cola to product, sell and do all the things in India. Bisleri gave all the authority to Coca-Cola for using the word Maaza, and they can use in India and they can sell it by the name of Maaza, right? So what happened is that when Bisleri was doing his business, Bisleri went to Turkey, and there in Turkey, what happened that they registered the name of Maaza in their own proprietorship, because in their own proprietorship, meaning thereby, even if you are giving the word Maaza to Coca-Cola in India, and you are going to Turkey to register that trademark under their own name. So Coca-Cola said that it is not the case. It should not be there, because Coca-Cola is using this word of Maza, and Coca-Cola is using the word of Maza in India. And if it is getting in Turkey, still the effect, since it is Maza and Coca-Cola is there, since it even if it is in Turkey, and even if the jurisdiction is different, since Maza has been already given, it will create confusion in the mind of people. Well, there was a lot of debate as to how it can create confusion in India and Turkey, but still they restrain give the temporary injunction to the distillery to use this word of Maza in Turkey also, right? And now comes the Cadila Healthcare versus Cadila Pharmaceuticals. This is also a very famous case of Supreme Court. What happened? Cadila Healthcare and Cadila Pharmaceutical are having the same goods and services, and same all the things which is being used, which is being manufactured. Scheduled drugs are being manufactured by both the companies. That is that they both are having same companies, but they both have the same domain, same name, Cadila. So they go to Supreme Court for having this infringement. It says that it is having the same infringement. So Supreme Court very well decided that okay, fine, both are having same goods and services, and both are also producing the same scheduled drugs. So there is a whole sole chance that okay, fine, this infringement is particularly valid because of their similar goods and services, and even similar scheduled drug price. In this, even essential factor of passing off was also being retaliated by Supreme Court, which says that okay, fine, both the rights have been given, both the things have been okay, fine, it's similar goods, passing off is there, but you have to make yourself very much understand that when you are going into the passing off, you have to see the nature of mark, the extent of similarity between competing mark, the nature of business, and the class of purchaser. So here, very much important is the class of purchaser, the nature of mark, the similarities in the terms of nature of good. So when you are going into the passing off, you have to make yourself very much clear, as per the retaliation made by Supreme Court in Cadila, that nature of good and nature of mark. That's why when I was dealing in passing off, I told you that no, you cannot. You have to prove that it is the same course of trade. So in this Cadila for healthcare, pharmaceutical and pharma case, Supreme Court retaliated the same thing about having a similar nature of goods and services and similar nature of things, right? So nature of good has to be make very much clear. You have to be very clear the nature of good, and the class of purchases are also very important when you are going for the passing off, right? So this was the case of Cadila Healthcare. Pidilite and Pomax, okay, this is very famous case, and also I have dealt with this whole issue of the photo. Fevikwik and Quick Heal, right? So this word of Quick Heal and Quick of Fevikwik was being infringed. Fevikwik said that okay, fine, you are infringing it. Similar to the case of goods and services, both are having goods and services which are almost similar. Quick Heal is also using the use of Quick Heal is also being done for this gum manufacturing, and this Fevikwik is also being doing the same business. So ultimately, this was a very easy case, similar goods and similar services, and hence the Pidilite industry won the case and get the permanent injunction on using of Quick Heal in this case, because Quick Heal and Fevikwik was both similar goods and services. Bata case, also a very famous case of, I think it is an Allahabad High Court case, whereby Bata is a famous shoe industry, but the same name of Bata was being used by the foam industry. Bata foam. Bata shoes and Bata foam was infringed. Bata says that it is an infringement of the thing. It is an infringement of what you say, the infringement of the word Bata. But the Allahabad High Court said that even if you are infringing the word having different goods and services, that the Bata is dealt in the shoes business. Bata foam was under the foam business. There are two different businesses, which Bata foam also says that I am using the word Bata in the two business, and my usage of business is different from that. The goods and services is different from that. So I will be allowed to use the term of Bata foam. But Allahabad High Court said that Bata is such a well-known trademark, and is such a trademark which if you are using Bata in terms of foam, there people can get confused that tomorrow Bata is also manufacturing foam. So Allahabad High Court gave a decision in favor of Bata and restrained the Bata foam for using the word Bata in terms of even having a different goods and services, or even having a different class. So make yourself very clear that even if you are having a different class, even if you are having a different product and services, still you will be refrained from using the same goods and services if it comes to the well-known trademark, or if it definitely create a confusion. A very famous case also, I'm not mentioning it, but a very famous case was also known as Daimler-Benz versus Haibo Hindustan. Haibo Hindustan used the logo of Mercedes in their manufacturing of undergarments, and similar contention was put by Haibo Hindustan that I am using the logo of Mercedes for the purpose of manufacturing undergarments, and this Mercedes is being used for the manufacturing of this something car, a high-tech car. So court says that no, even if you are using it for a purpose of undergarment, Mercedes is such a well-known trademark that your usage of even your usage of a logo or a mark which is different goods and services, which comes under different classes, still it will be getting a infringement. Still it will be getting something which is infringed in this sense. So you have to make yourself very clear, even if it is different class, even if it is different product and goods and services, you have to be very clear whether that mark is not a well-known mark, or whether that mark is not that level of mark which even if you are using for something else, like tomorrow if I use Mercedes for my let's say cow milk, I'm selling cow milk and said Mercedes, I will be definitely infringing. I cannot claim that okay fine, no, Mercedes is a car and I am using cow milk. So the court will not hear it, because court will say that okay, Mercedes is such a high profile trademark, or such a high profile trademark, even if you are using it for anything in your household, for any business, you're definitely getting, or you're definitely creating a confusion in the mind of people, right? So you have to be very clear. Classes and classifications, goods and services, that's why I take all those cases, so that you are able to understand that in one cases the facts are almost similar, but the decision is different, right? Facebook teach book, similar thing. McDonald McCurry, similar thing, but the decision is different. That's why I choose those case laws only, so that you are able to understand what is the importance of these classifications are there, right? And what is the importance of using this infringement area when you dream to deal with when you are dealing with these all sort of trademark. Last two cases, Zara case and DM Entertainment. Zara case was similar to the Bata case. Zara is a famous industry of I think it is an industry of manufacturing clothes and something like that. And there was a restaurant which opened as Zara. Zara said that this restaurant named Zara is infringing my trademark of that is well-known trademark of Zara. The same contention was being put. Zara is a merchandise which is used to manufacture these clothes and all these things, and I am using it as a restaurant. The court, I think again Delhi High Court, rejected it and said that this mark, even if you are using a similar mark, Zara is having thousands of outlets, and tomorrow if you are using it for a restaurant, you are creating confusion in the mind of people that Zara has also entered into the business of restaurant. So these are the well-known marks. DM Entertainment and Bay Gift House. DM means 𝗖𝗪𝗀 Mehndi Entertainment. 𝗖𝗪𝗀 Mehndi is a famous singer. We all know that he gave the right to the person, to a company, which says that they have all the right to use the name of 𝗖𝗪𝗀 Mehndi. They have all the right to use the name of let's say anything, the song of 𝗖𝗪𝗀 Mehndi, the song of anything that they can use. But this Bay Gift House used that 𝗖𝗪𝗀 Mehndi small toy. They used to make the small toy which shows 𝗖𝗪𝗀 Mehndi, and they are selling it and they are earning profit, right? So it was contended that the usage of Bay Gift House and making up a small toy of 𝗖𝗪𝗀 Mehndi is also an infringement, because 𝗖𝗪𝗀 Mehndi has already given his whole soul right, name and everything to DM Entertainment, and it's an infringement. It is, I think, the first case in India which talks about the celebrity merchandising right. Right. This was the case of Delhi High Court, that it gives an importance of how celebrity merchandising right is important in India. And even if 𝗖𝗪𝗀 Mehndi is big personality, we used to sing song and we used to play songs even, but still you are using it for a financial gain as making a toy, that will be definitely an infringement of celebrity merchandising, right? So this is the first case of celebrity merchandising, right? So these are all the cases. I think all these cases are very different, and you are able to if you are dealing with all these case laws, and if you have heard all these contentions being put forward by the courts in all these cases, you are able to understand how you have to differentiate and how important a class can be, and how important a class, even if there is a similar class but having different products, even if there is two different classes but still you can infringe. Even if you are having one class, you are able to you are infringing. Even if you have two different classes, you can infringe. All these cases are very interesting cases, and These are cases which make us learn as to how this importance of trademark classification is there, and one need to be very cautious when you are dealing with this trademark classification. I think trademark classification, trademark opposition, and trademark infringement is done. If anybody has any question, this is finished. If anybody has any question regarding this, and if you want to repeat any case laws, please let me know. Thank you.
All right. Thank you so much, sir. I do have a question. I was waiting because it wasn't really on the concept. So there is this one question: how to make reply either in section 9 or section 11?
Similar to that case of opposition, when you are having an objection under section 9, as you are giving a counter statement in terms of opposition, as you are giving the counter statement in when you are dealing with the opposition, similar counter statement has been given in terms of section 9 and section 11 also. You are having all the right to go for the section 9. You have all the right to prove your evidences. You have all the right to go for any documents. You can prove any documents, and you can put any documents to the trademark office so as to prove that, okay, fine, your reply under section 9 and section 11 is being given. And you can prove that even if it is objected under section 9 or 11, you have further rights, and you can further substantiate as to how you can move forward with the trademark registration.
Thank you. Are names of scientists, leaders, etc. prohibited? Example using Kalam in education and science.
Yeah, exactly. Yeah, all people are having these comes under the domain of celebrity rights, right? And the celebrity rights are these are like if you are using it tomorrow, if you are doing something from, let's say, you are making a music and you are saying Shah Rukh Khan, so yeah, you are definitely infringing the rights of that person. That's why I told that even 𝗖𝗪𝗀𝗀𝗻𝗃 has given it. 𝗖𝗪𝗀𝗀𝗃 has given a right to DM Entertainment, but still you are using this toy, toy for 𝗖𝗪𝗀𝗀𝗀𝗃. It's infringing, right? So you don't have the right to use these names in scientists and sciences. This is where this will come under infringement. Those people they can sue you under infringement.
Right. So I think we can take this one last question. In case of passing off, we need to prove, we need the evidence that the trademark has been in use. So what exactly can be an evidence? What kind of documents can?
Just repeat the question, sir.
In case of trademark infringement, in case of passing off, we have to prove that the mark has been in use, right? So what could be a possible evidence of proving that a person has been using this mark for a long period of time? What could be the documents, or what could be the evidence?
You don't have to prove your other documents. You have to prove your document. You have to go to the court, and you have to explain the court that you are using this trademark even if it is unregistered. The only thing that you have to prove is that the using of your trademark by some other person is injuring your goodwill. This is something which you have to prove. And again, as this Cadillac case was there, which you have to prove that this trademark, the nature and this purchaser, the class of purchaser and the nature of goods and services is similar. But more importantly, you don't have to go to other person and to say that, okay, fine, this person is using and this person is infringing. You have to prove your own point, that even the using of that person is injuring your goodwill, not his goodwill, right? There is also one concept of reverse passing off, which I didn't deal with. Reverse passing off is similar. Like if you are a defendant, and if defendant, let's say if you are using a product of plaintiffs and you are showing that this product is being used by you, this is called as reverse passing off. It is very rare, but you don't have to go for other person. You have to just prove yourself, okay, fine, this is person which is using it. No need to say for how long he is using it. Just prove that it is injuring your goodwill. That is also very difficult to prove, but just prove that it is injuring your goodwill, and this is something which is very important. Injuring a goodwill is very important, and causing a financial harm is very important. This is the thing.
Right. I think with this we have come to the
Yes, I think some other
conclusion.
questions are also.
No, we have covered most of the questions.
Question answer I can see.
Okay. We just received one more. How can advocate become trademark attorney and trademark agent? What is the process?
No. You trademark attorney. All advocates are trademark attorney. You have to be very clear the difference between a patent agent and a trademark agent and a patent agent. In a patent agent, you need to qualify an exam, And for that, you need to have a science background. Either you have done BSc or BTech, something like that. And then only you are eligible for sitting in the patent agent exam. And after getting a stamp of patent agent, only then you can go for a for a registration of patent. But in trademark and trademark attorney, even I am the trademark attorney, even Akshay is a trademark attorney. So all people, all advocates, there is no prerequisite rule to have a trademark agent, or there is not an exam. You just need to put yourself into the domain of you just need to register yourself, and that's it. There is no prerequisite commissioning of having a trademark registration or a trademark, becoming a trademark agent or trademark attorney.
All right. I also wanted to clear one thing. So if you
Yeah,
fail to
I
if
think
you fail to right, right. If you fail to
what
please go ahead. So
please
please go ahead.
I'm saying that there is one more question, but Ayushi is art. What if that celebrity is endorsing that brand? Even then, is it illegal? No, when you are endorsing a brand, you are having you are having a, what you say, a licensing agreement, whereby all those celebrities and all those people have a licensing agreement with with the company, and then due to that licensing agreement, that company is using the name of your name. It's like if you Amitabh Bachchan, they are using that name. That is under the domain name of what you say. That licensing agreement is there, so it's not an infringement. This is something. This is a licensing agreement. It's because of that, right? Please ask Akshay. You are saying something.
Right. So, so once a trademark is in process of registration, and you've been using that mark even earlier, and you fail to give an opposition, then what remedies would you have when that trademark is registered by someone else?
Uh, can you just repeat it?
What would happen if I fail to make a representation in front of trademark registrar while opposing? I mean, what if I fail to make an opposition when a trademark is being registered, which is infringing my trademark? I've been
Your
using a mark from
your
earlier,
trademark
but
is your trademark is unregistered or registered?
my mark is unregistered, but I have been using it from earlier, and I failed to make an opposition when someone else was registering it. What rights do I have now?
That again, you have to prove that this mark is being used by you from day earlier. First, secondly, again coming to the point of injuring, but that becomes a very important point, because when that person is registering a trademark, then you are getting a 4 month time to oppose it, right? And if you, even if in that 4 month time, if you're not opposing it, or either you are not able to oppose, no issues for that. But still, even if it is registered trademark, you can go to the court and you can just ask and say that, okay, fine, you are my trademark, I am using this trademark from a day earlier, and this is injuring my goodwill. As per my experience, it is very difficult, because since he is registered trademark, he is getting all the remedies by law, right? And he has done all the things, all the due diligence work in previously. So again, if you can prove it that it is injuring your goodwill, it is injuring your financial growth, well and so good, you can go ahead, but you have to prove it. And if you're not able to prove, then no issues, then you are intended to be liable. You have to prove it, the goodwill.
All right, all right. I don't see any more questions in the Q&A box as of now. So
I think
can
there are
we?
some comments.
Let me just check the chat, and let's be sure if we are not missing anything. Can you
Dilution of
explain
trademark.
the dilution of trademark?
29 clause 4 is the dilution of trademark. Dilution of trademark is very, I think this trademark dilution comes under the existence and under the lot of debate by what we see coronal, where Supreme Court said that coronal, by the use of coronal word by Patanjali, is cannot be restrained. So dilution of trademark is similar to that. When you are having, suppose if I am having a mark of, let's say, any ABC mark, and if somebody is using it, the using of somebody's else mark, we both have same mark, but that somebody else is using the same mark as of mine, and that same mark is depleting the or diluting the uniqueness of the mark. Yeah. uniqueness of the mark. This is the concept of dilution. You have to prove that okay, coronil was there. Coronil, I have registered the word coronil in 1993, and Patanjali comes at 2020 and saying the word coronil. Coronil is the use of word coronil is diluting the word because it's diluting the uniqueness of the word coronil. That is what the trademark is there, right? So dilution of trademark 29 clause for you. It's a very simple concept. Anything else?
I'm not seeing any question in the chat.
You don't have to register any for any court, Tina Sharma. You don't have to register as an attorney, trademark authority. You just only need to go to that IP India site, and there is all process is given. You don't need to go to the court or any bar council to register as yourself as a trademark attorney. Like patent agent, no, for patent agent, the authority is this IPI India, right? So that is only the intellectual property in the authority is the main thing. You don't need to have a bar council registration for this trademark authority.
What is the provision for dilution? That is
29 clause 4, Shraddha. 29 clause 4 is this dilution. 29 clause 4. Is it clear? Anything else?
All right. Please write down your questions. If you have any questions, please put it down in the chat. We can answer them one by one. Or if there is no question, then still we can just wait and.
I can also see the comments if possible.
Right, right.
There is one, I think, question. Can you please explain what kinds of documents can be given to evidence to show a long use of? Sorry, this is something which has been done, right?
We have taken it, sir.
Evidence is something which is from which you can prove that okay, goodwill is there and goodwill is lost and you are having a financial loss. That's why I told you that it's very difficult to prove. Because how you will prove goodwill? You cannot bring thousands of people in the court and say it's देखो सब जानते हैं मुझे. So that is very important.
While registering trademark for client, should we register on behalf of client or as attorney?
On behalf of client, not as an attorney. Client has the all right. Yeah, there is one. I forgetting the name. It's power of attorney is being given. Yeah, the power of attorney is being given, so you are registering on the behalf of client. So if anybody needs, if anybody has any other confusion, I am writing my mail ID. You can connect me. You can connect me over Saransh Chaturvedi09@gmail.com, and you can also give me suggestions if possible. Trademark is a very huge topic. We have a lot of things again, like trademark dilution, as she asked. Even that trademark dilution consists of a lot of other particular small domains. So if you want, trademark dilution can also be a subject topic of a one webinar. Registration, and even if you can go to the nice classification, how to categorize yourself in the Vienna codification, how to go for the nice classification. These are all are very in-depth analysis. So if possible, if anybody will say, I can also do it.
Right. So you can always write out to Mr. Saransh for these topics, or you can also write out to 𝗧𝗿𝗀𝗀𝗀, and we'll definitely try to bring these topics and bring webinars on this topic. It was a great experience to have you, sir, with us today. I am not seeing any queries anymore. I've been waiting. So can we conclude this today's session?
Yeah, sure. It's all
right. All right. Yeah. Thank you so much, sir. Thank you so much for taking out time and doing this webinar with us. I'm hoping to host you even more and do more topics with you. Thank you so much, everyone who participated in today's session and also raised queries. You can always follow to 𝗧𝗿𝗀𝗀𝗀 on different platforms, and you can keep a tab of different webinars. You can also check out our specific courses in intellectual property we are offering. You can just go to the courses and check that. Thank you so much, everyone, for joining in.
Before going, sir, just one thing I will say. I think one comment is there to share the previous link of previous session link, right? So if you are having any doubt regarding selection, how to do with the arbitrary, I have dealt comprehensively with all the details of all the marks. So it's available on the YouTube of 𝗧𝗿𝗀𝗀𝗀 website, YouTube 𝗧𝗿𝗀𝗀𝗀 channel. You just have to prove trademark selection, and there is I am dealing with all these things of small things of how to deal with this trademark selection, because trademark selection, if not understood, it is very difficult to go into the trademark classification and other things. So you can go to the YouTube for seeing this, right? Thank you so much, Akshay. Thank you.
Thank you so much, everyone.